Good morning, everybody. It is good to be back. Really good to be back. Probably miss you guys more than you miss me. I can assure you that. We had a great holiday here, but now it is back to business. And there is a lot to cover today, this morning. So I'm glad you're all with me today. A few different updates have been going on, and we have to get through them. And we will do our best to do that in a timely fashion, as we always do. Just take a moment to say good morning to everybody. Where have you been? I missed you. I missed you guys too. It's been too long. All I can say, it's been too long, and I'm glad that we're back. Good to see everybody is back and in good spirits so far. We'll see how the spirits continue as we continue the show today. So there's a lot to get through. And we're going to talk about Kelsey Fitzsimmons. We're going to talk about Ian Whiffen by popular demand. We're going to talk about the Karen Reed phone hearing. We're going to talk about the new attorney that's made an appearance for the O'Keefe family. Talk about Turtleboy. Talk about possibly some defamation chatter that's been going on. So we've got definitely what to talk about. But before we jump into the subject matters today, I want to tell everybody that it seems that all the trials that we were about to jump into and cover, so for example, Brian Walsh, you were all getting all ready for that trial, and then last minute, he got admitted to the hospital for like 20 days to be checked out to make sure that he can stand trial, that he's competent. So that got pushed off. The au pair trial was also supposed to start, which would have been actually worked out nicely if Brian Walsh would have got adjourned for a couple of weeks so we can cover the au pair trial and then move on to Brian Walsh and then move on from there to Courtney Clenny, OnlyFans model, that trial. So that was what we had geared up, ready to go. And then everything got adjourned. Everything got pushed off. So now what is really there to talk about? So we still have some leftover issues with Kelsey Fitzsimmons and Karen Reed and Turtleboy, but probably not much more is going to be going on with those cases until the next hearing for Turtleboy is going to be December, and December 5th, I think it was. So we're probably not going to hear more about that. We haven't been hearing about any new motions that are going to be filed in that case. So that may take a little lull as well. So I was thinking, went back to the lab, trying to figure out what we should be concentrating on. And I think some people are getting a little bit tired with all the pretrial stuff, all the motions and the research that we show. I mean, that's always good to me, but I think people want to see a trial. And yeah, you can kind of just jump onto the next trial that Court TV is playing, but it seems like not much of that has gotten a lot of traction. You know, people haven't been hearing about some of those trials. So what are we really going to cover? So that's why I was thinking with my team about what to cover. And I was thinking, I never saw the Casey Anthony trial. And I know that even on our chat, which we've been talking about the Karen Reed trial or other stuff, Casey Anthony keeps coming up. And the question is whether she was acquitted, but the question is, did the jury get it right? What were the, what's the legal analysis on that? And I haven't seen it. I never saw the trial. I know some people have very strong opinions about it. So I'd really like to stream that trial. We've got a couple weeks now before anything probably major is going to be happening anyway in all these other cases that we've been following. So unless something major hits and there's a new trial that everyone's all of a sudden pumped up about, we can change gears. But what I'd like to do, yes, I am, and by the way, I did see this. I'm familiar with the Curry Richards case. Yeah, I know there's been some new updates with the Curry Richards case as well. Trial's not set for that for a while. I know there's been updates with that. So yeah, that's also something that we're going to be keeping our eye on as well. But that's why I was thinking that I'd like to, with your permission, with your interest, to stream the Casey Anthony trial and break it down just like it's going on right now. And I can give my full attention to that trial and see what I come out with. So I know some people, it's hard to watch that trial. They saw it already. I think a lot of people got into the true crime world after the trial already. And a lot of people are new here. So I was thinking about streaming that. I got a lot of positive feedback when I put out the question on Twitter. So I think we're going to be doing something like that. We'll have the trial going. And also it's a little bit easier because we can hopefully fast forward through some of the lulls in the testimony or breaks and lunch breaks, things like that, we can just kind of just marathon it straight, and we can work with our own schedule. We don't have to be up at 6 o'clock in the morning so that we can be sitting in our office at 9 and ready to go. So we can play around with that and make sure that it's convenient for everybody. So I think that's what we're going to be doing. I'll definitely try it out. And if there's not enough interest in it, if people are not interested, then we'll stop. We won't do it, because I'm here for you. I'm here for the people. I am personally interested in the trial. I just hear about it. I don't know much about it, which is good because you can just come straight with completely being objective, not hearing much about it, and just watch the trial beginning to end. Not following any of the pretrial stuff that happened, any of the motions that were filed in that case, nothing. Just going straight to the trial and seeing what's going on. So I think that's what we're going to be doing. So you're welcome, obviously, all to join us while we do that. I think it should be an interesting trial to watch. A lot of opinions about it, and you probably want the objective analysis from Brother Counsel on it. So that's what I'd like to do. So that is just in terms of what we're going to be concentrating on next. I think it was a good, 2-3 week trial. So we'll see. I mean, it can take as long as, if I have something coming up, some sort of hearings that I have in my own cases. I know I got some of those coming up. So we'll do that. I know that here's another question from Kyle Sharkey. Can you give your opinion on the new motion on Proctor's phone? I did see that briefly. Maybe we'll get to that at the end of the show. But I want to concentrate really on some of the other stuff, which I think is very important. Definitely the Kelsey Fitzsimmons case, because that's something that as soon as I started covering it, something was very often troubling and, quite frankly, as I've been termed it, sickening about that case. So I want to talk about that. I don't know if my voice sounds okay. I know the holiday kind of knocked me out a little bit, and I'm just getting my voice back. So hope it's not too grating on your ears. But let's jump into the Kelsey Fitzsimmons case. So as most of you probably already know by now, Kelsey Fitzsimmons was shot. Now, the question is, what caused her to be shot? Okay, but that's neither here nor there. I mean, that really has little to do with the analysis that we have to run through in order to see what happened in her case. So Kelsey Fitzsimmons was shot. Question is whether she was pointing the gun at the officer or pointing the gun at herself. And she was in the hospital for 53 days. Then there was she was let out on bond eventually after she was micromanaged by the judge exactly how the release conditions were going to work out. What were the release conditions going to be? And one of them was that she had to blow into the scram device. She had to blow into the scram device with broken ribs and all other types of injuries, as you can imagine, after being shot. So, very simply, her attorney, very good attorney, Tim Bradle, filed a motion to amend and modify her release conditions. Pretty common motion. And then at the hearing, the judge decided, well, we're just going to revoke her bond and lock her up. So then there was a motion for reconsideration that was filed. The motion for reconsideration was denied. Most motions for reconsideration are denied, but it was denied. And then there was an appeal to the SJC. And with that appeal, there was, we were waiting on that opinion. The opinion came out during the holiday. So I got the opinion. We're going to talk about it. And let's pull it up. Let's get started right away on that opinion. It's a short opinion, but I think it brings some very interesting things to discuss. And we'll see whether they got it right. Okay, so here's the opinion. And let me just blow it up here for a moment. Okay, so this is it. The matter comes before the court. Justice Duar on the defendant's petition pursuant to that statute filed on October 2nd, 2025. The defendant seeks relief from an order of the Essex County Superior Court dated September 11th, 2025. What a date. September 11th. Vacating a prior order of release and ordering the defendant held without bail pursuant to 58A. Now, we actually discussed the difference between 58A and 58B. We're going to talk about that again because it's very important to understand which statute the judge is relying on and which statute she may be in violation of. So that is an important part. The judge issued a further written order on September 16, 2025, denying the defendant's motion for reconsideration. Commonwealth filed in opposition, yada, yada, yada. And there's really not much analysis done here. Just following close review, they find that this judge found, this justice, that the judge did not commit an error of law or otherwise abuse her discretion. Accordingly, it is ordered that the petition be and the same hereby is denied without hearing. Okay, so now You guys all know how much footnotes are important. Okay, so this is what the footnote says. Again, I don't know why this is not in the body of the opinion, because this is really what it all comes down to. You'll remember that when Bradel filed the appeal, we went through that, and he really concentrated on 58B. And we're going to pull up the statute in a moment, but I want you to read. We're going to read this together, and it's important because we have to see what the judge's opinion is and what the justice, again, the judge at the Superior Court level, McCarthy, what her opinion was, why she ruled the way that she did, and now what the single Supreme Court justice decided to, and what decided to order, and what the reasoning is. So listen to this. Contrary to the suggestion in the petition, meaning this is the suggestion that Bradel made in the petition, the judge did not revoke the defendant's bail pursuant to 58B, 276 58B. Rather, pursuant to the last sentence of 58A. We spoke about the difference. We'll talk about it again in a moment. But first, let's read what this justice said. Second paragraph. On motion of the defendant, the court reconsidered the bail order and concluded that because of a change in circumstance that had arisen, which was the defendant's inability to comply without intense pain with in-home scram alcohol monitoring, a condition of release that the court viewed for reasons stated in the court's order as critical to reasonably assure the safety of another person and the community, which is, again, the biggest joke in this case, the fact that Kelsey Fitzsimmons presents any sort of danger to Officer Noonan at 5'3" at 110 pounds. That's what Kelsey Fitzsimmons is also suffering from the injuries that she has. So that, again, that was the biggest joke of this order. But that is what the judge held. So it was critical to reasonably assure the safety of another person and the community. If the defendant were to be released on home confinement, no conditions would reasonably assure the safety of the named person and the community. As the Commonwealth notes, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that, going back to the footnote here, information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of another person of the community. So that was 58A sub 4, second paragraph. Okay, so what the judge, this single justice, the Supreme Judicial Court in Massachusetts is finding is that the reason that McCarthy revoked the bond was not pursuant to 58B, but 58A. And remember that Bradel's appeal really focused on 58B. And if you run this analysis through 58B, McCarthy was dead wrong. There's no question about it. The error is obvious because there was no violation. 58B only applies when there has been a violation of the bond or the pretrial conditions, release conditions. There was no violation. That was clear. So, as I told you before, McCarthy, the judge, the first judge, had to figure out a way to apply 58A. And if she's able to apply 58A, then she can say, well, this is not based on 58B, which requires a violation. This is based on something else, 58A, which would be what? According to this justice, again, this is on the appeal, it's that the court concluded that because there was a change in circumstances, meaning that Kelsey could not blow into the scram device without intense pain. So now there's a change in circumstances. So now we can sua sponte, meaning on our own, on the judge's own volition, on her own choice, she can now revoke the bond. Okay, but if you actually look at the opinion from McCarthy, let's see what it says. Is that the reason? So let's take a look. Here is this opinion from McCarthy, the original opinion on the motion for reconsideration. So let's just take a quick look at this, and we'll see if that's what the judge found. McCarthy, that is. In the specific context, this is going to the discussion part. We're not going to read the entire opinion. We already read it a few times, probably. In the specific context of persons held pursuant to 58A, the hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained if the judge finds that information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person or the community. More broadly, Massachusetts Rule of Criminal Procedure 13A5 empowers a judge to reconsider any pretrial motion which has been heard and denied upon a showing of substantial justice. In this case, there is nothing in the motion that was not known to Fitzsimmons when this matter was last before the court on September 11, 2025. So the Judge McCarthy is not in this opinion saying that there's a change of circumstances. Show me where in this opinion she said that there's a change of circumstances. She didn't. In fact, she's saying just the opposite. There is no change. There is nothing in the motion that was not known to Fitzsimmons when this matter was last before the court. Now, we explained why the judge also, McCarthy, misunderstood the entire 58A statute, but nevertheless, she stuck with her own analysis. And her own analysis was that there's nothing new here. There's no change of circumstances. But because the judge is allowed to always revisit, and this is where she gets into her real analysis, instead, a judge always, I should highlight this. Instead, a judge always has the power to reconsider his or her own decisions during the pendency of a case. So that is what she's relying upon. She's not relying upon a change of circumstances here at all. It's just straight on the opinion. So she's relying on this citation to a case law, which says that a judge always has a power to reconsider their decisions during a pendency of a case. A judge is always allowed to reconsider it. But it's not that simple, because there's other considerations that the judge also has to take into account when you're dealing with taking away someone's liberty. So the first thing I just want to point out here is the fact that the SJC, in their opinion, said, again, that the court reconsidered the bail order and concluded that because of a change of circumstances that had arisen, which would have been a little bit of a better analysis by McCarthy, but she didn't do it. This is what the SJC is reading into her opinion, which doesn't exist. And then saying, well, that's what she must have been relying on. Now, I want to show you that even if she was relying on that, there's still problems. There's still problems. But just on its face, this is not what McCarthy's reasoning was. Her reasoning was simply a judge is always allowed to revisit her previous rulings, period. Nothing to do with change of circumstances. So that's just flat out wrong. That's an error by the SJC. Okay, so let's move on, because I want to show you the actual statutes here. So remember, there's a difference between 58B, as you can see, this is 58B, and this is 58A. Okay, so now again, 58B, this is the most obvious statute, which is in favor of Kelsey Fitzsimmons, and reasons why this order should be vacated, which wasn't, unfortunately. And from the first sentence, a person who has been released after a hearing pursuant to sections, etc., and who has violated a condition of release, his or her release. So that is what 58B is all about. And that's essentially what happened here. This was a revocation. So you can really already make the argument when you have two statutes that conflict with each other, what should you do in that case? Which is all bodies of law about what to do when statutes conflict with each other. In which favor does that go? But that's a whole other area of research that wasn't done in this case. So it's the SJC could have done that, but they didn't. Okay, but this was 58B, and this is really what Bradel focused his appeal about. 58A is a little bit different. Okay, now 58A is very interesting, because if you look at subparagraph 4, which is what was cited, right? I believe that was 4, right there, 4, says the following. When a person is held under arrest for an offense listed in subsection 1. So what is this statute talking about? When the person is already under arrest, not when the person's already out on bond. That's what 58B is for. 58A is when the person is already being held under arrest. Then there's all this language here, all this talk, and then this is where the SJC thinks that McCarthy is relying on, which again, we showed that she was not relying on it, but for the purposes of just the analysis of the SJC, let's see if this holds any water. The hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained, if the judge finds, etc., that information exists or there's a change of circumstances, right? But what's very blatant about this statute is that it's talking about a person who has already been under arrest. They are being held, and you want to get the person out. That's 58A. Was Kelsey Fitzsimmons being held under arrest when this motion was heard? No. And again, the hearing may be reopened by the judge at any time before trial upon a motion of the Commonwealth or the person detained, which again would very clearly suggest that we're talking about, this statute's talking about the person is already detained, is already being held under arrest. And now you want to do something about it. You want to get the person out. That's where this statute applies. Okay. So that's just two main errors that we see already with the SJC's opinion here. Number one, it quoted a reason that was not found in the opinion on the motion for reconsideration. That was not McCarthy's opinion. It wasn't because it was a change of circumstances. She did try to relate everything to 58A, but that's not what she said, that there was a change of circumstances. She should have said it. I thought she was going to say it, but she didn't say it. And then even when you look at 58A, it's talking about a person who is already being held under arrest or detained, not a person who's let out on bond. When a person's let out on bond, then you go to 58B. So the whole thing here is a little out of the ordinary, okay, and trying to apply the wrong statute to this circumstance. Now, let's move on, okay? What about the idea that a judge can always revisit previous rulings that they made, right? What about that idea? Right? That was something that McCarthy actually cited in her opinion. A judge can always revisit the opinions. Well, you can't always revisit it when it has to do with taking away someone's liberty, locking somebody up. We have a constitution. This is why I said that there's constitutional implications here. It was not constitutional what happened. Not just looking at these statutes and trying to figure out which statute applies. That's a different analysis. There's a separate analysis that has to be done when you're taking away someone's liberty. Okay, and for that, just to show you, you got to go to this case. This is in the matter of a minor. And I think this is actually a case that was quoted very often in the Karen Reed case. Let's take a look at this. The 14th Amendment to the United States Constitution and the Massachusetts Declaration of Rights establish a fundamental right to liberty and freedom from physical restraint that cannot be curtailed without due process of law. You can't forget about due process. Anytime you're taking someone's liberty away, you have to run through the analysis of due process. The right of an individual to be free from physical restraint is a paradigmatic fundamental right. Laws that directly infringe on fundamental rights, such as liberty, so you have a fundamental right here, from constraint are subject to strict scrutiny. So anyone who's taking constitutional law or common law 1, even common law 1, probably you get this in law school, is that if you have a fundamental right and you're trying to infringe on a fundamental right, such as liberty, it's a pretty important one, you're subject to strict scrutiny. To pass the strict scrutiny standard, the law must be narrowly tailored to further legitimate, compelling government interest and be the least restrictive means available to vindicate that interest. So, for example, in this case, the interest that the Judge McCarthy was relying on, why we have to lock Kelsey Fitzsimmons up, is because she's a danger. She's a danger to Officer Noonan, and she's a danger to the community. That's a valid interest. I'm not saying it's not a valid interest. Of course, that could be a valid interest. But now you have to run through the strict scrutiny. Well, let's think about it. You have somebody who has been shot, who's 5'3" at 110 pounds, and what possible danger can she be to the community or to Officer Noonan? And then you have to think about, what are the least restrictive means available? What are the least restrictive means? Is the least restrictive means locking her up? Is that the least restrictive means? Yes, the judge can revisit her rulings, but when it involves taking away someone's liberty, then the 14th Amendment applies, and you got to run through this analysis. Due process. This is strict scrutiny. This is a fundamental right. What's the least restrictive? How about the person's on house arrest, and she only gets out to go run to do this urine testing at some place? That seems pretty restrictive and fine. Everyone's going to be safe. But this analysis was never done. And there's some case law that says that the judge has to run through this analysis. They have to show why the only means available to get this, to vindicate this interest, is locking her up. She has to run through the analysis. Let's think about everything that I'm talking about. We have to run through all the means available and then figure out whether these means are the least restrictive available. Locking her up is the least restrictive. There's nothing else that we can possibly do to guarantee the safety of poor Officer Noonan and the community at large. So this wasn't done. And by the way, I mentioned when I saw the appeal that this is something that was lacking from the appeal. Okay. There was no due process argument that was made. It should have been made. Now, this is a valid argument. I think it should have been made. This is an argument that can be made. And this is what applies, I believe, in Kelsey Fitzsimmons' case. So this wasn't done. And that's unfortunate why she has to now be locked up in a cage. So that is as it relates to Kelsey Fitzsimmons. Let me just see what we got here on the side before we move on to the next thing. First of all, thank you, MM, for becoming a new BCU member. Thank you for Annie H, 8511. Great coverage as usual. Love from Great Britain. Jamie Hayer, 56. Thank you very much for that. I love the way you explain things. Thank you for educating us. So thank you very much for that. And that is as it relates to Kelsey Fitzsimmons. Now, I know people wanted me to get into the Ian Whiffen stuff. I don't know why it's like people are going to get excited about this, but we can talk about it briefly, and I'll tell you something that stuck out to me. Okay, so maybe you've seen this interview. This is an interview that was done by Celebrite. So obviously they're going to be trying to stick up for Ian Whiffen. But this was where he didn't really win the case for the Commonwealth, I would say. And just before we get into this, the Google search to me, if you've been following my channel at all from the beginning of the Karen Read case, the Google search to me was really, really not important. Really not important. Why? Because it has nothing to do with whether her car hit him. Now, you're right. People that are sunk into the conspiracy theory and they think that all the McCabe's and the Alberts were part of this, then it's very important to them. But as a lawyer, looking at this case of what the prosecution has to prove, as opposed to what the defendant has to put up a defense for, the Google search to me didn't really bother me that much. I don't really care that much, and I think that the defense shouldn't have concentrated on the Google search at all. Now, people ask me, what do you think? Do you think the Google search happened? Do you think the Google search did not happen well, I shouldn't say did it happen. Did it happen at 2:27 or did it happen at 6:30 in the morning? And my answer was, I don't know. I saw two experts. They talked about it. A lot of the stuff was over my head, probably a lot of people's heads. And they're talking about Celebrite. Usually Celebrite gets it right. This is probably the first case in history where Celebrite got something wrong, or that's what the claim is. So there's some questions. There's some serious questions. Yeah, Ian Whiffen tried to explain it, but then they had Rich Green say that it wasn't. Okay, and there's other tools that Rich Green used and showed that the search did happen at 2:27. So my answer to that is I don't know, and it doesn't really bother me that much because that has nothing to do with whether Karen Read's car actually hit him. We had so many experts say that the car didn't hit him. I don't really care about the 2:27 search. And my approach to this seems to have been the way that the defense presented in the second trial. Remember, I had Yannetti and Alessi on this channel. We interviewed them after the trial, and I asked, we were talking about this 2:27 search. And I asked them, why do you care about the search? I don't remember the exact words that I asked the question about. I was like, what do you care about the search so much? You're trying to now switch the burden. Now you're trying to prove that there is a conspiracy. That's not what you have to do as a defense. So why do you guys even care so much about the 2:27 search? And in fact, remember, they did not call Rich Green. They didn't call any forensic expert in the second trial to try to explain how this Google search happened at 2:27 in the morning. And you'll remember what Robert Alessi responded to me. He said, well, Martin, you remember that we did not call any experts about it and really care so much about it. So why did I ask the question? Well, because Alan Jackson made a deal about it in the opening statement. And if it was me, I wouldn't have said it at all in the opening statement. I would have just completely ignored it. Now, I said maybe he wanted to mention in the first, or maybe I would have mentioned it, but not put a lot of stock into it or, focus on it so much. And I felt like Alan Jackson did that and he didn't really need to do it. And perhaps he was doing that to create a rabbit hole that the prosecution would feel that they have to run after, which they did. But they still mentioned in the opening statement. And that's something that, I don't think that there was a great answer. Maybe there was some discussions about it. I couldn't get 100%, transparency about everything that was going on in the back rooms there. But They did mention it in the opening statement, and I felt that it wasn't necessary. So the whole 227 search to me is not really so important. I know the people that are sunk into the conspiracy theory, it's very important to them. Did it happen? Did not happen? To me, it doesn't really matter that much because that's not my focus on these trials. All right, so that's the best you're going to get from me. But let's just talk about something that stuck out to me by Ian Whiffin's interview here. Okay, so he's being interviewed by Celebrite. So this is a Celebrite interview, and of course they're going to try to pump him up and say how he's amazing and everything. But listen to this first question, which really had me scratching my head, and I think that the defense would have liked to know this beforehand. But listen to this.
And we'll have some fun at the end too. All right, why were you brought into this case?
Okay. So I initially got involved in this case after a true crime podcaster contacted Celebrite asking for clarification because of some things that he'd seen in other people's blogs, some things that had been tweeted related to an artifact that Physical Analyzer had passed. Basically, police had obviously extracted.
Okay, let's stop there for a second. How did he get involved in the case? What was his answer? His answer was that a true crime podcaster reached out to him. And that was really news to me. That's how he got involved in the case, because I remember when he was asked on, and this is the second trial, and this is also in the first trial, he was asked the same question, and listen to his answer here, how he got involved in the case. I'll just slow it down just there.
Let's turn now to your involvement in this case. Can you share with us when you first became aware of the data in this case and how that came about?
Yes, it was actually one of the public relations managers at Celebrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp. And requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
Well, that's what we all remember from the trial. So he said that he got involved because Rich Green reached out to him and a public relations manager reached out to him and some investigators. So public relations, investigators, and Rich Green. Those are the people that reached out to him. That's how he got involved in the case. That's what he testified under oath. And then you have this interview with Celebrite where he's saying that he got involved because some true crime podcaster was reading blogs, watching videos. Who's that? And it seems like he was watching stuff from Turtleboy. If I had to guess, the blogger, that's what his name is, right? That's what he refers to him as, the blogger. So is that how he got involved? That some true crime podcaster reached out to him? Or was it because he was contacted by Rich Green? Which one is it? So that was something I thought stuck out to me in that interview. And the rest of it is just talking about everything that he talked about in the trial. That he believes that the search didn't happen at 227. Okay, but I thought that was interesting, all of a sudden. All right, so that is as it relates to Ian Whiffin. I don't think it's so interesting, the whole 227 search in the first place. Maybe it did happen, maybe it didn't happen. I don't really have an opinion one way or the other. I think it's a question. We have battle of the experts, whichever expert you want to believe. But as a lawyer looking at this, I've got experts on both sides, and I don't know. I can't tell you whether it actually happened or not. So that's the best that I can give you. And it really doesn't play so much in my mind about the outcome in Karen Reed's case anyway. So that is with Ian Whiffin. Let's move on to Karen Reed and the Karen Reed phone hearing. Okay, so now we know that the Cosgrove and the Commonwealth now want to get into Karen Reed's cell phone. And there's a lot of speculation of what they're going to find in that cell phone. Are they going to find certain text messages from Karen Reed to Turtleboy saying, go harass witnesses and let's conspire together to commit witness intimidation? Are they going to find some smoking gun like that? That's the question, and that seems like they're going after. Now, like I've said before, this would probably be one of the biggest mistakes the Commonwealth can possibly make. Bring Karen Reed into Turtleboy's case. That would be probably the dumbest decision I can ever imagine. Now, it's not comfortable for Karen Reed. I bet you she doesn't want to do that. She does not want to sit through another trial or be next to Turtleboy, and especially now they're going through all this, drama, whatever it is. I don't care. But that's not what Karen Reed wants. But I can assure you that for Turtleboy, he would want nothing more than that. He would love to have Karen Reed right next to him, bring all the crowds, all the attention, have Karen Reed's lawyers there, have Mark Betterow and Tim Bradle on his side, have 2 shots at every witness here to cross-examine. I mean, that would be Turtleboy's dream. Okay, now I'm not saying that he orchestrated this and he had anything to do with it, but if the Commonwealth really wants to charge and try to get her indicted now for conspiracy to commit witness intimidation, I don't think it's a great idea, but it seems like they're posturing for that. Okay, so this is what their posture is, and let's see what happened just quickly at the hearing, because people were calling my name again. This happened during the holidays, so I wasn't able to be involved in it, but just a quick view of what happened at the hearing. So this is what happened. There were some filings back and forth. We spoke about some of the filings. The Commonwealth suggested a taint team, which they have no problem footing the bill for, right? They have no problem paying for the taint team. What's Massachusetts tax dollars anyway? They already spent who knows how many millions of dollars prosecuting Karen Reed. They have no problem trying to do the same to prosecute Turtleboy. Okay, for all you taxpayers in Massachusetts. So they have no problem paying for it, and they suggested a protocol, and the Karen Reed's attorney came in and he filed an opposition why they should not be able to get a hold of the phone. Now, there's one main case that they're talking about, which we're going to talk about soon, which is, again, why I'm not overly impressed with Karen Reed's lawyer here and his job in responding to this motion. Okay, but let's just listen to what happened, and we'll take it from there.
As cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search.
Okay, so Diaz, what's the case Diaz? Diaz is a case where there was a warrantless search of the phone. Okay, very different than what happened in Karen Reed's case. There was a warrant for her phone. Okay, now whatever you say about the affidavit to the warrant to the phone and Tully's affidavit, that's beside the point. There was a warrant for the phone. So Diaz is a case which talks about a warrantless search of the phone. And that seems to have been what Karen Reed's team or attorneys were relying on to deny this motion. And this is where the judge asks the Karen Reed's attorney, well, what do you say about this case? Not Diaz. Diaz is a different case. What about this case? So take a look what happens here.
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here,
And that's another way of saying no. But okay.
the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones, or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5-year delay on doing DNA testing to see if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness...
Okay, so basically here, the judge is saying, well, where is the case? Where's the case? Yeah, and then he said Diaz. Well, Diaz is not the case that talks about when you have a warrant and they just sat on it for a year. Now, yes, you can argue reasonableness of time and things like that, but if you don't have a case that discusses that situation, then the judge is going to be inclined to agree with the Commonwealth, which is what seems like Judge Krupp is going to do in this case. So he took it under advisement, but I don't know if there's been any supplemental filings. And this is something where people are saying, okay, brother counsel, you find the case. I just didn't have time to do the research on the case, but that's what you have to do. If you see this motion and it's about a case, you try to find cases that are similar to your set of facts. And if you can't find any single case like that, then you have to start trying, maybe going to other jurisdictions or whatever it is, to try to find similar scenarios and then applying it to the situation here. And that didn't happen. So what the next thing is that the judge said, well, he didn't respond to the protocol. There was a protocol that the Commonwealth laid out about the TAIN team going through exactly how they're going to go through the phone and make sure they're not going to have discover anything that's protected and things like that. So that is something that the Commonwealth proposed, and the defendant, Karen Reed's attorneys, did not respond to. Well, what's the protocol? So what he did was he said, okay, you've got till tomorrow, actually October 21st, I think he said, that you have to just respond to the protocol. And there's probably going to be no response to the protocol. And really, it was just you guys work out the protocol. If I'm going to agree, which looks like he's going to agree, and he's going to grant this motion, if I'm going to grant this motion, well, then what's the protocol? And do you have any objections to the protocol? And what's going to be with that? So that wasn't done either in the response. So again, not a great look. I mean, we're kind of used to Alan Jackson and Eliza Little and their writing, and Robert Alessi, who all write very well and do the appropriate research. But it wasn't a good look. I mean, it just wasn't a good look for Karen Reed's attorneys. And by the way, this is kind of a pattern that we're starting to see with Karen Reed's new attorneys on the civil side, as well as with this issue, that you're seeing the difference in when you have Alan Jackson and Eliza Little working on a case, and when you have some other attorneys working on the case. Now, I don't want to put anybody down, but I mean, I think this was a miss, and there's reasons for perhaps Karen Reed not to be so happy with the work that was done if now Judge Krupp is going to grant the Commonwealth's motion in the first place, and then they just have to figure out the protocol. So that's what that. Let's kind of segue. That should kind of segue into the new attorney appearing on the O'Keefe family. So now we're moving to the Karen Reed civil case, right? So we got Karen Reed criminal case, we got the Karen Reed phone case, and now we have the Karen Reed civil case. So there's a new attorney that appeared for the O'Keefe family, high-powered LA attorney, supposed to be a very top-notch personal injury attorney. Okay, and that's great. She's got like $100 million verdict, and now the O'Keefe family is bringing her on for the case. So what do I think about that? I'm not so concerned with what attorney is trying this for the O'Keefe family. If this was me, again, when I have the facts on my side, when I have the law on my side, I don't really care who's on the other side. I've gone up many times against a team of lawyers on the other side, right? You know, how we saw in Karen Reed's civil case where there's like attorneys all on the bench and then even on the first row, and everyone's making appearances for Karen Reed, and there's just two attorneys on the other side. Sometimes it's been me on the other side, and there's a bunch of attorneys on the other side. It doesn't really bother me how good of the attorney it is. If I've got the facts, if I've got the law, then I'm going to win. I don't care how many attorneys are on the other side. So it doesn't really bother me, or I'm not so concerned with the new attorney who's representing the O'Keefe family. There's one thing that this case is about. It's always going to come down to the same thing. It doesn't matter how good of an attorney he is. I don't think that this really has to do with who's a better attorney and what type of elaborate arguments you can make to convince a jury one way or the other. You can be the most suave and a great attorney in America, and if you don't have an expert, you don't have a real accident reconstructionist who's going to show you how this accident happened, you can be the greatest attorney in America. Nothing's going to change that fact. So it doesn't really matter how good of an attorney it is. You can have the best attorney in America. You've got to get, if you're the O'Keefe family, you got to get a real accident reconstructionist to show and run a real accident reconstruction to show how this collision happened and how the injuries resulted. If you don't do that, then I would bet on the other attorney, no matter how experienced that other attorney is. Now, what's more concerning for me is the fact that I'm not as impressed so far. And again, things can change in my mind. But so far, what I've seen from Karen Reed's civil case, and again, Alan Jackson really was not so involved, and it seems like he's just going to be brought on for trial if this goes to trial. But I just haven't been so impressed with the writing, and I haven't been so impressed with the oral argument. As you know from my last video, I think that the O'Keefe's family attorney, was it Mark Dillard? I think he did a better job at that hearing and briefing than the other side. And that's how I would be more concerned about for Karen Reed, that she has a good set of attorneys representing her, even though, like I said, I think in this case, it comes down to experts. It comes down to that ultimate fact. And you've got La Posada, you've got the ARCA experts, you've got Russell, you've got all the experts on your side. Who are they going to really hire to combat your experts? That's really what it comes down to. So it doesn't really matter to me. It doesn't bother me who they get. They can get the best attorneys in America until they show me an accident reconstructionist who does a real reconstruction, not the blue paint garbage that we saw, but a real accident reconstruction. Then we can start talking. And then maybe it may come down to the attorneys. Then it may come down to a better attorney who's able to present this better, who's able to convince the jury of believe my accident reconstructionist over their accident reconstructionist. That's what it's going to come down to. But until they do that, it's not going to matter who or which attorneys they hire. Okay, so that is my opinion as it relates to this new attorney that the O'Keefe family hired. All right, now let's move on to Turtleboy. Let me see if there's any more comments here. Thank you very much, Gina Gomez. Yes, FBC, the Constitution matters. I would think so. I would hope so. Talking about the Constitution, we're going to talk about the First Amendment in a moment, which is an important one. After all, it's the first. You may have heard that from me before. All right. We have Mrs. Denuzio. Sorry if I'm saying your name wrong. I always appreciate your insights. Thank you. All right. Thank you for that. All right. So let's get back to what we're talking about. Okay. So now let's move on to the Turtleboy recent motion. And we're not going to go through the entire motion because it's already getting late. And probably a lot of you know about the motion. So, but I do want to just point out a few parts of the motion. Let me just blow it up because I didn't blow it up before. Okay. And this has to do with Lindsay Gattani. So the motion to disqualify Cosgrove. And this is also something where Brado wanted to bring up at the last Karen Reed hearing, that perhaps we shouldn't be setting all these dates and hearing motions for summary to dismiss if the Cosgrove is conflicted. But as the judge said, you have a motion, he has the right to respond. And until I make an order that he's actually conflicted, and if he believes that he's not conflicted, an attorney can represent somebody. So as long as the attorney has a good faith that he's not conflicted, he can represent the client. Okay, so this is what happened with Gattani. Just very briefly, Ms. Gattani, as we know, had a number of communications with Catherine Peter and Jennifer McCabe, and she made some videos about it. And now, so she's got these videos. Ms. Gattani is a material witness regarding numerous important issues in the 2023 case and the 2025 investigation. Cosgrove was already disqualified from a different case. So now they just want to also say that he's conflicted from these cases as well. And by the way, let me just say this before I go through this, is that if they find that he's convicted, if they find that he's conflicted out and the DA is going to be conflicted out, there is no one that's going to prosecute this case. Okay, because the DA already tried to get the AG to prosecute this case. They weren't interested. The DOJ and the AG, they weren't interested. So if the DA is conflicted out because they're being sued by Lindsay Gattani, and Costco's being sued by Lindsay Gattani, and Tully's being sued by Lindsay Gattani, well, then there's going to be nobody that's going to prosecute Turtleboy. And there's reasons why nobody wants to prosecute Turtleboy, because it has to do with the First Amendment. And First Amendment is important, as you all know. So let's just go through a little bit of what the allegations here are. We know that she was in contact with Tully and with, it seems like she's in contact with Mello about this prosecution and perhaps appearing for the grand jury, or she was going to be served a grand jury summons. And here we go. So Ms. Gattani is a material witness, including but not limited to how the Commonwealth investigated and built its case, the shoddiness, bias, and or lack of good faith in the Commonwealth's investigation as a witness at a pretrial hearing, suppression of any evidence obtained from Ms. Reed's phones, the relationship between Mr. Carney and Ms. Reed, and explaining how Mr. Carney and Ms. Reed communicated on the substance of those communications, meaning this intermediary that there was Natalie and whatever, all that good stuff that you guys all know about already. If Gattani was in the middle of all of it, then she's a witness. If she's a witness, then guess what? Costco can't represent the Commonwealth and call Gattani as a witness when he's being sued by Gattani, right? That doesn't work. So Ms. Gattani also is a material witness who will be called to impeach several prosecution witnesses, including but not limited to Tully, Mello, Peter, and McCabe, Jennifer McCabe. So, okay, she made a series of public statements. We don't have to go and rehash all of this, but the point is, and this is a very strong motion, as you know, it's written by somebody who knows how to write motions, Mark Betterow, not just the font and the 14 size, but You guys already know how much I appreciate and enjoy Mark Meadows' writing, but he lays it out very, very fine. He lays it out perfectly. Lindsay Gattani, if she's a witness in this case, then Cosgrove has to be conflicted. There's no way around it. So the only thing that Cosgrove is going to be able to do, try to argue with the DA's office, is that there's no conflict and that really Gattani was not involved at all. And they're going to have to bring receipts, as you guys love to hear that terminology. They're going to have to bring receipts. And if there's not enough receipts, then guess what? There's going to have to be an evidentiary hearing to see what type of involvement was she involved in, who she spoke to, was she going to be called for the grand jury summons or not. It's not going to be enough, and it shouldn't be enough. Again, we've seen all types of crazy things happen in Massachusetts, but it's not going to be enough. Again, it shouldn't be enough just to say in a motion, yeah, she wasn't involved. And here's, one exhibit showing that, or here's an affidavit saying that she wasn't involved. That's not enough. That shouldn't be enough. There's going to have to be an evidentiary hearing on this issue. So, and again, if Gattani was a witness or somehow can be considered a witness in this case, and someone that the defense is going to call, then the prosecution, Cosgrove, and the DA's office is going to be conflicted out, and there's just nothing to talk about. And then Turtleboy is going to be scot-free. So, as you guys have already known, I already offered Lindsay Gattani to come onto Brother Counsel. I think this would be a great opportunity for her to come onto the show. I already had Turtleboy on the show. He kind of said over his story, and he's continuing to say his story over, and he's the one that's facing 100 and so odd years in prison. She's not facing anything. She's not being charged with anything. So he has a lot more to lose than she does. And she was invited onto the show. She wants to come on and tell her side of the story. We can plug her, her Substack, whatever else she's got going on for her. And it would be a great opportunity for her to share her story with the world on a very fair, objective Brother Counsel show. So invitation's still out there. Ms. Gattani, you know how to get a hold of me. And we can definitely do this. So I think a lot of people would like to hear whether you were involved or you're not involved, just come out and say it. So that is as it relates to Turtleboy and Lindsay Gattani. The next date for that is going to be December 5th. So there's still a while for the next hearing date on Turtleboy's motion. I want to talk very briefly, about the defamation claims that people are starting to throw around about Turtleboy. Okay, because a lot of talk about defamation about the people saying Karen Reed's a murderer. Is there any difference? Is there any difference between calling Karen Reed a murderer or Turtleboy calling the Alberts and McCabe's murderers? Right? Is there any difference? And where does this all fit in with defamation? Okay, so I want to just talk about this very briefly. We're not going to do a tremendous deep dive into all the research about this, but you're going to have to take some of my word for this. So the way the defamation works is the first thing that you have to prove with defamation is that the person who was stating the defamatory statement was stating a fact. Okay, not an opinion. That is the first question. Is the person stating a fact or an opinion? And here's another important part. It doesn't matter if the person tells you I'm stating a fact. Okay, I can say, I am stating to you a fact that Brother Counsel is the most handsome law tuber. And I can say that it's a fact. It's still an opinion. It's still an opinion. And other people may think, some of you out there may think that there's others that are actually more. So it doesn't really matter what you say. I know this as a fact. If the statement is in itself an inherent opinion, it's not going to help. And I know I already see everybody in the chat saying, Peter Tragos, I tip my hat to him. Yeah, he's got me 100% down. I'm just giving this as an example, okay? Just give it as an example. All right, so that's the first thing. So the first thing that they have to prove is that when Turtleboy said anything that he said is that he was saying it as a fact and not his own opinion. Okay, that's number one. Number two is that the statement has to be false. It has to be a false statement. You have to prove that that statement was false. So if you say, I know for a fact that Brother Counsel on Sunday at 11:55 a.m., October 19th, 2025, was broadcasting from New Jersey, that would be false. I'd be able to prove it. I am in Michigan. It's a defamatory, well, it's not defamatory, but it is a false statement, and you know it's false. And you said it with negligence. And when it has to do with, depends on what type of citizen, we're not going to get into that, but it has to be a false statement. Okay, so that's where actually there's a difference between when it comes to Karen Reed and Turtleboy. Okay, because Turtleboy can say, all right, go ahead, prove to me. You have to prove now in court, aside from getting fact beyond whether this was just his opinion, which anyone who watches his shows understands that everything that he's saying is opinions, even though he's saying a lot of things as facts. And sometimes he shows you receipts, but a lot of it, 90% of it is opinion, even though he says it's fact. So that's number one. Number two is it false? You have to prove that it's false. So with Karen Reed, the argument is that they proved that it was false. The jury are fact finders. That's what we call juries. And the jury acquitted her, which would be an argument to say that anybody who says that Karen Reed is guilty is going against the fact. There was a fact finding in the previous trial that she was innocent or that she's not guilty. Okay, now I'm not saying that that's a winning argument, but that's the difference. The difference is that the McCabe's and the Alberts were not on trial. So you'll go, okay, go ahead, prove to me. You are going to have to prove that what he's saying is false and that he said it with negligence, meaning he doesn't have enough evidence on his own to believe that what he's saying is true. Meaning if he would be reasonable, if he would have done, used due care and looked into all the facts of the Karen Reed case, then he would have realized 100% that they are not guilty. So that's another burden that they'd have to prove. So what I would say is that I don't think, and again, anyone can file lawsuits against anybody else. I mean, this happens every day of the week. People file lawsuits. Some of them are frivolous and some of them aren't. And I would caution you that even though anyone, the courthouse is wide open, anyone can file anything at any time against anybody. Innocent people get sued all the time. Okay, so anyone can get sued for anything. But if you file a frivolous lawsuit, there can be some serious sanctions against you. So you should be careful about that. You should be very careful about who you're deciding to sue or not. And there's been severe sanctions often when people are filing frivolous lawsuits. Anyone can file, but that is scary business or risky business if you're not 100% clear about the elements of the defamation and that you can't make a serious, reasonable argument for each of the elements, which again, fact has to be false. And the person who said that didn't necessarily have to know that it's false, but it has to have acted with negligence in determining that that statement was false. Okay. And I think Turtleboy would still get up on the stand and say he has all the evidence that it's not false. So they have to have another trial basically about this. All right. So that is, I think, for the defamation part, as it has to do with Turtleboy, because I know people are throwing around that information or those allegations that maybe Turtleboy is going to get sued in defamation. Maybe he will. I mean, it could be he has enough enemies that people will sue him because they don't care and they'll just sue him. And they'll try to figure out any sort of cause of action to cause him to stick. He doesn't have everyone. Not everyone is his friends, right? But I think it would still be a very uphill battle to try to get him on defamation. Okay, so I think that is really going to do it for everything we had to cover. Let me see if there's any questions here that I didn't get to yet. And we'll try to take it. Oh, we could still go through the Brian. Okay, maybe I'll show something on the Proctor stuff, but let me see here. Sass and turkeys. Is it possible Cosgrove will be conflicted off Karen Reed phone case because of Lindsay's involvement as well? That's an interesting question. That's very possible. If Lindsay Gattani is involved, then anything that she's involved with at all, and she's going to be a witness on, would disqualify Cosgrove and the DA's office. So yeah, I think that's a good point, and that's a good that's a reasonable conclusion right there. Kyle Sharkey. Kelsey, would or can you file a new motion for an in-person hearing before a full SJC panel as the next step? So I know there are certain instances where you are allowed to file for the full SJC panel. I did not do the research. There are instances where you could, but it's very time constrained. You have to do within a certain amount of time. let me see when this opinion came out. Let me just pull it up here. Let's see. When did this opinion come out? October 15th. So there could be, I think the limit, there's probably still within the time when they could file for the full panel. That is possible. But there are limitations. I mean, you have to do the research, and I did a very briefly research about it, but there is a possibility. I will just leave it as that. It is a possibility as the next step. Thank you very much, Miss Lily C, for becoming a new member. Semi Sharp, hope he sees my question. Where is it? Where's your question, Semi Sharp? I didn't see it. Let me see if I can get back to your question. Here we go. Is there such a thing as being bullied with the courts? Perpetual frivolous charges and lawsuits. Well, there are charges that could be brought that are meritless. Yes. You know, like they say, even a ham sandwich can be indicted. So it's very easy to indict someone. So I'm not going to automatically say that it's automatically frivolous. If there's probable cause, which is very easy to get, then you could be charged with something. But like we said, it's a very, very low burden. So anyone can get charged with almost anything. That's as the saying goes. Lawsuits, as I said, anyone at all can sue anybody else. You can do it in pro per, as Lindsay Gattani did it. You can talk to an attorney. Now, hopefully, if you talk to an attorney, the attorney will look at the merits of the case and will decide whether he believes or she believes that there's actually merit in your lawsuit. That's what I do before I just file. I don't just take everything that my client's telling me. I try to look into the facts and make sure that what I'm filing is, I have a good faith, that I have some reasonable cause of action here that I'm filing about. So you would hope that that is what happens before attorneys file lawsuits. So if people are talking to attorneys about filing lawsuits or potential lawsuits against Turtleboy, they would definitely know defamation and the elements, and they would look at the shows. They should look at the shows and look at the tweets or whatever he's saying, and they should understand whether there is a reasonable chance that they have merit in their case. Let me see what else we have here. I don't know why I can't really see the chat as well as I usually do, but we will get there. Okay, I want to just show, maybe I'll just show this one thing. There was, just to quickly let you know what's going on, it seems like, with the Proctor stuff. Okay, so let me just blow this up for a moment. Oops. Wrong. All right. So this is the, let's see what this is. This is a Commonwealth's notice of discoverable information from former trooper's personal phone. So maybe you've seen it, but the bottom line here is that there is an unexpected volume of files that were discovered on the cell phone of Michael Proctor. I'm sure some of you are shocked. The review of the extraction is not yet complete, but the Commonwealth requires additional time to complete its review of the data extracted from the cell phone. What a surprise that the Commonwealth is asking for more time. Again, this is, I think this is actually may have filed in the Miles King case, but they were allowed to look through the phone, and the extraction has yielded hundreds of thousands of items, some of which are dated as far back as 2013. And here's interesting. Proctor's counsel on July 25th, 2025 and August 12th, 2025 filed a motion and amended motion for clarification, which noted that Proctor changed phones in February 2024. Another person changing phones. Nothing odd about that. Did not preserve his old phone. Nothing odd about that. And after activating his new phone in February 2024, used an auto delete feature. Nothing odd about that. Deleting the contents of his phone over every 30 days. Counsel proffered, therefore, regardless of the time frame for the court's order to be clarified, it is unlikely that Mr. Proctor has any relevant information in his possession concerning the case. Well, it turns out that there is relevant information, and they're just not turning it over quite yet. So that's all that's happening with the Proctor stuff, is that the Commonwealth has found certain things. They found certain things, and we will see what they actually found. Right? So there is still what to be learned from Proctor's phone, whether it relates to Brian Walsh or Miles King or any of the other prosecutions that he's involved with. Let me see what else we have here. Gina, great insight and knowledge of the law. Thank you very much for that, Gina. Member for 1 month, Ellen Fagerland. Thank you. Missed you and your great insights. Looks. Thank you. Look, I'm not going to sit here and say that I can hold anything over Peter. I mean, Peter is the OG. I mean, he's, I'm just a little guy here, and I had a great conversation with him actually, and hopefully we'll do it again. But I mean, I was just using that as an example. Come on, guys. Let me see what else we have here. Here's a question from MB Sense. Can the DA get away with giving every defendant the same Proctor extraction file after the privilege review, or do they have to cull it as applicable for each one? My understanding is that they can't just give over everything. No, they're not allowed to do that. They have to look through the phone and figure out which text messages or anything else that he did on the phone is relevant to that specific case. And they have to itemize it, they have to separate it, and then that's what they have to turn over. They don't have to turn over everything. So you don't have to turn over things that are not relevant to the case. So yeah, each individual case is going to require a different review to make sure that they're giving only what's relevant to that specific case. JC Music, man, what if they find that Proctor took a pic of Karen's taillight intact? Well, if they did, it's too late at this point. I mean, well, it's not too late. It'll help her in the civil case because that civil case is going to be interesting. So the civil rights violation, if they have any sort of information or evidence that they knew that the taillight was intact, that is going to be very strong evidence for her 1983 action. So they would love that. Nothing more than that. All right. Here's a question from Ms. Lilly. Is this new download under protection of feds? And I'm assuming you're talking about Proctor's phone. And my understanding is everything's protected right now, which is why they had to go through this whole, all these hoops to share the downloads. So they're trying to figure out how to get around all this and make sure that they're not going to be in contempt of any federal order. So yeah, from my understanding, it is. Here's a question from Explain how John's DNA and hair got on the back of Karen's SUV. I mean, are we relitigating this case now? I don't know. How would a boyfriend's DNA get on the back of his girlfriend's car? Can anybody think of any ideas? Anyone? Any ideas at all? How John's DNA, who is a boyfriend for 2 years of Karen Reed, how would that DNA get on the back of her car? This is another thing that I think people are thinking about. Brother Counsel, do you think they should postpone Proctor's hearing for getting his job back until they see exactly what is really on his phone? And that is I was thinking about this actually myself, because we know that he's in the middle of trying to fight to get his job back, and they're only talking about the extraction of what was shared in Karen Reed's case. And if it turns out that there's some other misconduct that happened with his phone, I think that would have to be a separate hearing, because again, there's something called due process, which would mean that if they can't just lump it now, throw it into this case and say, well, now you have to defend against this also. I would think that it has to be separate. I think it'd have to be a separate charge administratively for another reason, another finding about why he's not fit to keep his job. So I think that if they find anything more about what he said about Brian Walsh or Miles King or any of the other defendants that he was investigating, it would have to be probably a second administrative hearing. He'd have to go through all the steps again. They'd have to find that he's, again, unfit to be a police officer, and then he'd have to appeal that all again. So I think it would be a separate hearing. Here's a question. Can the feds enter into the civil case? Now, I think what you mean is, can they be called in the civil case? You'd have to figure out which part of the federal investigation of the people that are involved that have witnesses, like ARC experts were hired. So they were hired and they have relevant information, and therefore they should be allowed in the case. Anyone who did a federal investigation and is not, and the feds want to provide, they could. But if you're going to, it would be, again, you'd have to go through the same steps as getting ARC involved. ARC was involved. They had relevant information. Therefore, they wanted to bring them in the case, and the feds allowed that. So if they find out any more information about anyone who knew more about the case, they can potentially call them as witnesses, but it's not so easy always. Here's a question. When will you start the Casey Anthony trial? I'm thinking about starting tomorrow. I'd like to start, again, if you're just joining us now, I'd like to live stream the Casey Anthony trial because nothing really else is going on now. And all these cases that we've been talking about, it doesn't seem like there's going to be any new filings, but if there is, we'll cover it. But just it seems like it's going to be a little bit of a lull in the true crime world. So I'd like to cover Casey Anthony. I'd like to watch the trial, rewatch the trial with all of you, and give my recaps and give you my legal analysis, any research that's necessary to do that, and just take a fresh look at it. I've never seen it. I didn't see it, and I'd like to see it because there's a lot of opinions out there about what happened there, whether the verdict whether the jury got it right, and I'd like to see it myself. So I would like to do it tomorrow. So stay tuned. Brother needs a decongestant. Yeah, unfortunately, I'm still trying to get over the holiday blues that I got. I hope it don't sound too bad. You should have heard me last week. Last week was not great. We'll be streaming the Proctor hearing this week. Okay, I didn't know that there's a Proctor hearing. So I'll have to look into that. If there's a Proctor hearing, maybe we will stream it. We'll see. But if we're doing Casey Anthony, I'm not sure. Maybe people are going to be more interested in that. Here's a question from Kate. If the O'Keefes use MSP and Canton law enforcement to testify, who pays for that, taxpayers or the O'Keefes? Probably they might both actually pay for that, because if they get summoned, then there's usually a witness fee that you may have to pay as the plaintiff, but the town also may pay for court appearances. I'm not 100% sure if that only works for criminal trials or even civil cases, but it may be both. It doesn't matter. Massachusetts has plenty of money. Don't worry about it. Kyle Shark, have you followed the Charlie Kirk assassination? Andrea Burkhart is starting to cover more of it now, going over gag order today. It's definitely a case that's on my radar. So we'll look into it as things heat up, I guess, in that case. But I mean, I obviously know about it. Everyone knows about it. So we'll see. We'll see when things actually start to heat up on that case, and whether they got the wrong guy. I mean, I guess that would be the only defense there, if they got the wrong guy. By the way, the Brian Walsh hearing is 2 p.m. tomorrow for the federal material. Okay, so that sometimes that's like 10-second hearing. All right, where are we at? Are we here? Are we not here? Okay, you got it. You didn't get it. Okay, now we're done. So a lot of times that Walsh hearing is very quick. Look, Joy says, Brother Counsel, can't wait for your thoughts on the Casey Anthony trial. Yeah, so there you go. Some people want the Casey Anthony trial. I'd really like to see it. And I'm getting some of this also, by the way, from Mama. I'll watch anything you cover, but I have to say I don't love the thought of giving Casey Anthony more airtime. Well, you know, you don't think about it giving her any airtime. We're giving her case airtime. Her case is important. It's it's the judicial system at work, and watching attorneys and talking about trial practice. So, you know, don't think about it giving her airtime. I'm not having her on the show or anything. Kelsey has a court hearing this week, the 23rd. Proctor's hearing is Tuesday, Wednesday, Thursday this week. Okay, so maybe we'll do that instead. You guys can let me know. Oh, right, the probate case. So that has to do with Kelsey Fitzsimmons and her the father of her son, or her fiance or whatever, was trying to take away, trying to attach the child custody payments, try to attach her house so that she can't sell her house. So I think that's what you're referring to. Thank you very much, Kate, for becoming a new Brother Counsel member. Here we go from Ellis Chester's mom. I never saw Anthony trial, so I would love that. A lot of people want to see the Casey Anthony trial and want to see it with Brother Counsel, and I can't blame you. But Joy says that he, and talking about the Kelsey Fitzsimmons case, he wants 18 years of child support in advance. Have you ever heard of such a thing? He's trying to get all profit from the sale of her house. His name is not even on the house. Yeah, I mean, his name doesn't have to be on the house. You know, if your spouse or ex owes child support and you don't have a reasonable belief that he or she will be able to make the payments, then you can start attaching their property. That's what they're doing. That's what he's doing. So I don't know if he wants 18 years of child support. I think, is that how old the child is? Just 1 year old. But the point is that he wants it attached because he doesn't feel that she's going to be able to make the payments. So if she's able to show at some point that she has a job, she's able to make the payments, then maybe they can, move to remove the attachment. Again, this is a little bit out of my world. I don't, and obviously none of this is legal advice, but I'm not intimately familiar with how this all works in family court. But I imagine that it's attached, and it has to be, you have to refile every, I don't know, a couple months or years, whatever it is, to continue the attachment, unless the person's able to show that they're able to pay for the child custody payments without being nervous that you're not going to be able to make the payments. That brother counsel Scott Peterson may be interesting too, with the new appeal documents filed and apparently bombshells of police changing dates on stuff. Scott Peterson, okay, that's another child we should look into. Tiff says he wants 18 years. Baby was born February 2025. Okay, so he wants 18 years, but I don't think necessarily that today they make the decision about whether it's going to be attached for the full 18 years. Like, I think if she gets out and she gets a job and she's able to make the payments, there potentially can be a motion filed. And again, I'm not intimately familiar with the procedure there in probate court, but I imagine that if she's able to get out of her circumstance now, get acquitted or get a deal, and then she's able to get a job, then the attachment would not last that long. Child support is based on income, not assets. That may be true, but again, in order to pay, if you don't have income, then it seems like you're able to attach their property. Looking forward to you streaming Casey Anthony. Never watched that trial before. I've only heard about it. Obviously, the defense will be something to pay attention to because they did their job and get her off. Yeah, so it's an interesting trial. I want to see it. I never saw it. I know people are talking about it, and people are still talking about it, apparently. Okay. All right. Well, everybody, thank you very much. It's been almost an hour and a half since we started the stream. I usually don't do these 3-hour, 4-hour streams. So today was actually a little bit longer than I usually go, but we did have a lot to get to today. I wanted to stop, take some questions. I'm happy to be back. I'm sorry if my voice sounds a little bit grating on you. You should have heard me last week is all I can say about that. And so keep your ears and eyes peeled for most likely the streaming of Casey Anthony. But Tiffany says, wait. What do you have? What do you have for me, Tiffany? And again, I know that the Curry Richards case is going on. I know that there's been something going on with the Curry Richards case. I haven't been following that so carefully. But Tiffany wants me to answer a question. Okay, so there was the question I think was about whether I saw the motion. If it was filed like a month or two ago, I did see it. About the probate court. I'm not so well versed on probate matters. I think, but I did see that motion that they want to get the hearing done. I think as soon as her bond was revoked. Yeah. So I think as soon as her bond was revoked, he filed that motion to hurry up the hearing so that he can get that order to attach her house. So I guess we'll see what happens this week. I imagine it would get granted. I don't know. Like, I don't know anything about probate court, so I probably shouldn't give you an opinion about it. I mean, if you take all the other stuff away and you just look at this from probate wise, that if she has to pay custody, if she has to pay child custody payments and she can't do it, it would just make sense that they can attach something. But again, I don't know. This is beyond my expertise. So I try to limit what I talk about to things that I know. All right. So again, thank you all for joining us today. And keep your eyes and ears peeled for the next, probably tomorrow, where we're going to be live streaming, at least probably the first day of Casey Anthony trial. and maybe something will change in the meantime, but just keep your eyes and ears open. All right, everyone. Thank you very much. We will see you next time.